ERISA disability appeals are challenging, usually for most people, because there's so much paperwork involved. There are medical reports, there are vocational reports, educational reports, medical experts who have to give opinions about your case. And all of that usually adds up to hundreds of pages of paperwork. And keeping track of all of it and organizing it into a persuasive appeal is burdensome. And that on top of the fact that you're disabled. A lot of people will suffer from emotional or cognitive issues, and at the same time as they're suffering these medical conditions, they're expected to produce a complex appeal that takes a lot of time, requires a lot of focus and a lot of energy, and a lot of times most people just don't have the ability, the physical or cognitive ability to do all of these things and submit all the right information to the insurance company because of your medical limitations. These difficult issues are compounded by the fact that you have short timelines within which to do them. If you don't satisfy these timelines, then you could lose your right to appeal forever. And if you decide to file suit in court to litigate this matter in front of a judge, then you won't have the ability to produce any additional documentation or evidence to prove your claim. What happens in your appeals process is the only thing typically that a federal judge would be able to use to determine whether or not you qualify for disability benefits under your insurance contract. So it's important as you're going through this complicated appeal process of producing all of the material evidence that is necessary to determine your disability, it's important to make sure that you do it with accuracy and completeness. If you don't, ultimately your appeal can be denied and there may be no recourse at that point.